Cool.
Hello, everyone. This is Jim Blackburn, and I'm happy to invite you back to my new guest, Duke Lineberry, an attorney from Wilmington, North Carolina, a family law attorney whom I've known for many, many years, on our podcast, Grit Stories of Resilience. There is no one better qualified to talk about grit and resilience, and the need for both, than a family law attorney, I don't think. Duke, it's nice to see you today.
Good to see you, Jim.
And it's nice to have you with us. And so you came to Wilmington, as I understand it, by way of Charlotte,
That's right.
the United States Attorney's Office in Raleigh,
Right.
where you hope to be an assistant U.S. attorney, as I was once one. It's a great job. And then you had the misfortune, I should say, of trying an admiralty case
Right.
against George Roundtree, an attorney, well-known attorney, a wonderful person in Wilmington. And they offered you a job and you moved to Wilmington, turned the U.S. Attorney's Office down, stayed with the firm for a while, and now you're in private practice by yourself and have been for 39 years.
That's right.
Domestic
I love
law.
it. I love it.
That's great. Why do you love domestic law? When I was practicing law, so many people would say that God Almighty, I just will do anything, but I don't want to ever do a domestic law case again. I just hate it. Why do you love it so much?
Well, the short answer is I see results. There are a lot of cases. I did insurance defense work in the admiralty for the first 10 years of my law practice. I did a lot of family law then too, but I did a lot of insurance defense and I hated it because there's always somebody, a non-lawyer, telling me what I could and couldn't do in my case. And there was a lot of insensitivity. It's insurance defense. I'm sorry to those guys that do that work, but we all went to law school because we wanted to help people. Honestly, we all had this ideal that we were going to reverse the injustices of the world. And there's no more area of law that has greater injustice than family law. You think about it. Husbands and wives, boyfriends and girlfriends, and now same-sex relationships. There's no greater area for abuse and injustice and unfairness than it is in that area of the law. And when you're dealing with children and people's finances and their livelihoods, the road doesn't get any harder than that. And the rubber meets the road first time you get in the courtroom, and it can be pretty gnarly. People come in the door in crisis. Everybody comes in that door in crisis. And what I have found over 38 to 39 years of doing this kind of work is that I find that I can bring people from that crisis point to a point of stasis where they can move on with their lives. And it seems to be very positive. And I can't tell you how many times I've had people come up to me years later thanking me for what I was able to do for them and to set them on the next course of their lives. And they've all seemed to have improved, and that just makes me feel good that I've done something positive, did what I really set out to do when I went to law school.
I used to always say that if you wanted to be a great lawyer, it was possible for every lawyer to be a great one. What they had to do was make it so that their client was better off when they left the lawyer, than they were when they first got to the lawyer. And if the lawyer improved their position or situation, that person was a great lawyer in my book.
Right. I mean, how do you define a win in a custody case? Just because your client got custody, that doesn't necessarily mean that you won. But when the kids are unaffected or maybe minimally affected by the transition, and the parties are able to negotiate the breakup in a way so that the kids are not adversely impacted and everybody moves on, that's a win. I don't care what you call it. I don't care how you define it.
What's a loss?
I've got clients that I make recommendations to. I think I know what I'm talking about. I've done it long enough, and they reject my advice and they go out and they do something stupid or they do the opposite of what I've recommended. And I have to fire them because they're not willing to listen to me. And I have to ask them sometimes, why are you paying me to advise you when you're not going to follow my advice? That's a loss for me.
Right. You said that there was no area of the law that had more injustice than domestic family law. What do you mean by that? What is injustice? And what are you talking about, really?
So the injustice that we usually see is someone who's falsely accused and does 30 years in prison until the public defender can get them off on a DNA test, which is rightfully so. And 30 years in prison when you were never guilty to begin with is an injustice. But in relationships, the opportunity for abuse and one party dominating the other, and the finances and the breakup of the marriage and the impact that has on children and the long-term impact that has on children, quite frankly, to me, I think is a greater injustice. You know, this is one of those things where I tell clients all the time, we're going to do the right thing, whatever that is. And my idea of a right thing and the other lawyer's idea of what the right thing to do is probably polar opposites. But in reality, we all know what the right thing to do is in a case. We ought to. And so to me, the injustice is when parties or lawyers are unwilling to do the right thing. And from my point of view, again, since my goal is to get people from crisis to stasis and to get them out of the problem that they're in, we need to do the right thing. We need to fix things. We need, as you said a minute ago, leave clients in a better position than they were when we found them. And so people will move on to a better place and move on with their lives intact. I can't tell you how many times I've seen cases where the parties were bankrupt. I've got a 200-year-old lithograph that's in French, but these two lawyers are walking through the hallway, and one of them says, "Congratulations on winning your case. Too bad the parties have become destitute in the process." And that's an injustice. And it happens every single day. Child support court is a train wreck, and there's so much injustice in child support court. Depending on who you are, it can be the payor or the payee, it doesn't really matter because of the system, because of the way it's set up. If people could agree and work things out, then both parties would benefit in the long run. But we're so hell-bent on winning or getting our way, then we continue to press injustice on each other. Does that make sense?
Yes. Well, let me ask you this question in a hypothetical. Suppose a person, man or woman, comes to your office during the morning or afternoon to meet with you. The person is likely to be frightened, worried about what's going to happen, worried about what your advice is going to be, worried about what it's going to cost, what your fee is going to be. And do you have a fee arrangement, a pay arrangement, or trying to figure out how to pay you your deserved fee? And they have a custody. They have two children, two small children, a house they own jointly. Both work, though one, let's say, dominates the other in terms of the income. What do you say to someone who comes to see you when they walk into your office the first time, man or woman? What do you say to them to put them at ease and make them calm down and listen to you?
Everyone who comes in my door is looking for hope. Yes. Bottom line, they're looking for some light at the end of the tunnel. And so what I hope to do, like a doctor, when you first meet with them for a diagnosis, or the mechanic who's going to talk to you about your car, I'm doing the same thing. I'm diagnosing the problem and then trying to figure out a course of therapy or a course of action that will help address the problem. We're kind of limited, obviously, a lot of times on how you deal, for example, child support. How do you deal with child support? Well, there's really only one way unless the parties can agree. But being creative and talking with clients about options, not just the run-of-the-mill standard response, which is pay me a fee, we'll file this and go to court and get a result. I think it helps clients and it allows the client to be involved in the solution to their problem. Clients are very resilient if you let them be resilient. They will happily come up with some options. They're happy to try things short of spending thousands of dollars to go to court, if that's a viable option. And clients are better at and more adept at knowing what the other side is going to do or how they're going to respond. I can't tell you how many times I have a conference that says, this is what it will cost if we can settle the case. This is what it'll cost if we have to go to trial. Which do you think the other side is going to be more responsive to? And that invites the client to be involved in the process. I think the lawyers who don't let their clients be involved in the process, and I see a lot of them because I get them secondhand from another lawyer who's had the case and the client has fired the lawyer because they didn't feel like the lawyer is being very responsive. What I find is that clients want to have a say-so. I've got 10-year-olds who tell their parents they want to be heard by the judge. There's some issues with that, of course, but it's the same discipline, same issue, that parties want to be heard. They want to be involved. They have opinions, they have ideas, and I'm perfectly willing to work with a client that I think has a viable, creative option, as opposed to just pay me, we'll file this thing and go to court.
You mentioned it just now that there were questions or issues with respect to a 10-year-old talking to a judge. Is it normal for a small underage child to get to talk to a judge?
Not really. It depends on how articulate the child can be. I've had 9-year-olds fully explain to a judge what they ought to do and why they ought to do it. And they have enough self-awareness to know that, hey, I'm only 9, but you know what, judge, this would work for me. And I've had judges rubber stamp it because it just made perfect sense. And then I've had 15-year-olds go, I don't know. So it all depends on their ability to articulate rational reasons for what they want. And but no, judges don't normally want to hear from 9 and 10-year-olds or 12-year-olds. And by the time they're 16 or 17, I mean, first of all, those guys really don't know what they want any more than 9-year-olds did. And then what are you going to do? How's a judge going to tell a 17-year-old this is what you're going to do when you have a defiant 17-year-old that can look at the judge and go, you know what, I can quit school if I want to. There's nothing you can do about it. Thank you, legislature.
What is the age in North Carolina when a child is no longer under the direct supervision or control of a parent?
18.
18.
We lose jurisdiction over kids when they turn 18. But now the legislature has allowed 16-year-olds to quit school. So in a sense, a 16-year-old can tell everybody where to go.
Do you ever see anything approaching compassion and understanding from one party to the opposite party, or is it just always stress and strife and anger?
No, I see quite a bit of compassion. I have a case where the husband is a criminal defendant in the case, and there's a real question about whether or not he is liable or guilty. The wife is sympathetic to his plight. The court is willing to give them the latitude they need to work their things out. They have 2 school-age children. And it would be easy for a lawyer to recommend shutting the other side down and not allowing contact. And we and the other lawyer and I have worked well with both of our clients to creatively work out an arrangement so that the children are safe and dad still has a relationship with the kids, because we don't know what the outcome of his criminal charges are going to be. It's the kind of thing where if he's convicted, the children won't see their dad till after they've turned 18. And if he's not guilty, it's all over. And in the meantime, we still have these issues that we have to deal with. And it can be really dicey sometimes, but the parties are willing to work together. I've had countless clients who have forgiven back child support, forgiven back alimony. They were willing to let certain things in property go because they just realized for the benefit of the entire family were better off not getting everything that they were necessarily entitled to. So there is compassion, and people, I have to remind clients, sometime you loved this other person, you had children with this other person, you all were going to have a life together, and now you're going to try and ruin all that, try and destroy what the other party wants to do in their life and keep them from advancing. And when you start putting some of those things in perspective, I find a lot of my clients still have that basic goodwill for the other side, at least enough so that they can get through the process.
When a new client comes to see you, at what stage in the relationship with their spouse are they generally at? Are they already separated? Often, are they living together? Are they where are they in the normal chain of events?
All the way across the board. I've had people separated for years before they come to me. One of my favorites was a case about 20 years ago, and the couple had been married in 1962. And here it was 1998, I think. And they wanted to come in together to meet with me. And so I'm asking about the date of marriage. Date of separation was 1967. And I said, when did you reconcile? Oh, no, we never reconciled. What do you mean? Well, he bought the house next to me, and we just let the kids go back and forth between two households. He has had heart issues. The oldest daughter is now a cardiologist on the West Coast, and she has said, Dad, sell your house, come out here and stay with me, and I'll take care of you. And the realtor had told them they had to be divorced in order for him to be able to sell his house. And when I said, well, you don't have to be divorced to sell your house. Oh, thank you, Lord. We don't have to be divorced. They were never intending to get divorced. So
the realtor had said they had to be divorced.
Sell your house.
Okay.
No, you don't have to be. And then, of course, I see people all the time who haven't yet separated. I met with a lady the other day who they're married 61 years. And she's ready to move on. She's boring. I'm done with him. I want a life. I'm not living a life. We go out to eat. How was your meal? It was okay. And, she wants more out of the relationship. He hardly ever talks to her. They've been married 61 years. But it's been like this for years. I said, well, when are we going to do something about it? She goes, well, isn't that the problem? I haven't done anything about it. I need to do something about it. So she's now in a hurry to go do something about it. So I'm having to pump the brakes a little bit for her to kind of work some of this out.
What do you think prompted her to come ahead after 61 years?
One of her salon friends. So barbershops and salons have a lot of legal advice going on all the time. I won't say that it's accurate in any way, but there's everybody giving everybody advice.
Well, you remember if you ever used to watch Andy Griffith, they had the barbershop, Floyd's barbershop. Floyd would always give advice to everyone. I think that's true.
My barber tells me that his job's no different from a bartender. They all do the same thing.
They talk to people, give advice. It's just whether it's over a haircut or a drink. I guess that's true. How many of the people who come to see you wind up in litigation in trials that actually go to a jury trial or a judge trial?
I used to say only about 20% back in the 80s when I first started practicing law. Now I would say it's probably more like 60 to 65%. And I attribute that to public perception of the legal process. Other lawyers who, for some reason, just don't believe they can make much of a living without litigating. And again, I'm going back to, there are plenty of us who one size fits all. You come to me, you hire me, we file this, we go to court, we might settle on the way, but we'll let a judge decide. And it just irritates me to no end that they're unwilling to try and be creative to work things out. So I think a lot of that just has to do with the status of the legal system and the profession. Used to be, I would get a call from a lawyer, older than me, of course, wanting to meet for lunch and to talk about our case. And he would say, bring your file. And so I'd bring my file, and they wanted to look through my file, and I would get to look through his file. And the idea was that in a collegial fashion, we were going to look at the other guy's cards and work this thing out. And that's what we did. More times than not, we would work things out because two lawyers understanding the basic rules and doing what we thought was the right thing to do for the parties, we would work stuff out. And together we would advise our clients, this is what you ought to do. And most of those people walked away extremely happy. It's hard to get a lawyer on the phone to talk to you about the case, let alone open up their file or to talk to you candidly about their client's case, because we have our system, I believe, our not only our law school education system, but the whole legal process has geared us now more towards litigation, more towards the conflict. And I think that's a shame.
If you had a brother or sister now married and in an unhappy situation with the spouse, and they would come to you and you didn't want to represent them because of the relationship as a family member with them, and they were determined to either work it out soon or get a separation, perhaps a divorce, what kind of advice would you give them in going to see a lawyer? What kind of lawyer, without naming names, of course, but what kind of lawyer would you want your brother or sister to go see?
Probably my first bit of advice would be to stay away from the lawyer who wants to do all the talking. The lawyer who wants to tell you what to do from the word go, and they map out a plan without any of your input, is not the lawyer that you want. They are probably very good at what they do, but they're not responsive to the client. Now, we have to be careful that we're not going to let the tail wag the dog. And at the end of the day, with the experience that I have, I feel like I know what I'm doing and I can give people advice. And I'm going to fire a client who won't listen to me when I think I'm right about something. But still, it's the client's case. And it's the adage, the customer is always right, does not apply to the law. Never has. But giving the client the opportunity for input and listening to what the client has to say actually helps me be more effective for the client and to tailor what I need to do for what the client needs. And so my advice then to the family member or the close friend would be, make sure that your lawyer is willing to listen to you and work with you on what you think is important, while you're balancing what the lawyer has to tell you.
Have you ever decided after meeting with a prospective client, say someone comes to see you this afternoon that you're looking forward to meeting, and after a few minutes conversation, you realize this is not what I want to do. I'm not the right person for that. Have you ever, I don't mean fire, they're not your client yet, so you can't fire them that way, but have you ever declined to take a client as a domestic client?
Yes. The best interview consultations that I've had are the ones where I turned the business down, knowing full well that the client was going to be a problem from the start. And those are usually people who don't want to listen to anything I have to say, and B, their animosity towards the other side is so great that it overwhelms their reason and being rational. And when I see that, it's really is a recipe for disaster. We can get sideways with our clients real quick. And hopefully it's not because of us, but we get sideways with clients because we're not doing what they think we ought to be doing. The other one is the one who comes in and says they've read this on Google, their friends told them that, and they got a brother that this is what happened in the brother's case, or this is what happened in their mother's case when they were kids. And, they're always comparing somebody else's case. And I've never had two cases that were exactly alike. And so that's a person that I want to stay away from when they are not willing to listen to what I think to be a better plan for them. So yes, I have turned down quite a bit of business, and some of it very lucrative, and I turned it down anyway. And I realized later in talking with the lawyer that did take the case, who then later fired their own client and got tangled with the state bar, that was probably the best thing I ever did.
What advice would you give another lawyer or perhaps a client to make sure that the client's wishes are known, for example, and that the lawyer is protected? What is the relevance of note-taking by both sides when somebody comes to see a lawyer? Should a client take notes or make notes, and should the lawyer make notes to a file, that sort of thing?
Well, I'm not a journaler. Some people journal. I don't have time. I'm not self-aware enough to be able to write down my thoughts about my life. I can write down thoughts about somebody else's life, but usually I'm just trying to get the facts. Clients, on the other hand, want to know about process, and I'm okay with them making notes. In fact, I've had plenty of clients want to record the interview. And I've told them that's fine. If they want to record the interview, go ahead. I'm not going to be offended by that, because I know that what I'm telling them, I've been telling clients for 39 years. So I'm pretty confident that what I'm saying is correct. And if the state bar were to sit here and listen to the interview, I wouldn't be bothered by that at all. I would tell lawyers, though, when they're meeting with a client, to look for the red flags. There are a lot of young lawyers out there that are hungry, and they just take anything that comes in the door. And I think that's a grave mistake. When you start early, turning down cases that you can recognize would be a problem, that is the best decision you can make in your career. And take the cases that you know you can handle and the ones that you feel like you can really make a difference in.
You mentioned red flags. What other red flags, if any, have you seen or do you see in taking a case?
The level of animosity is a red flag. When I've got someone in here who's just spitting vinegar, they're so mad at the other side, and they won't calm down. I can talk to them about the case and try and here's some solutions. And they don't want to hear about the solutions. They just want me to go and get the other side. That's not productive. And I've fired those people as quickly as I can, or didn't take their case. It doesn't always pop up in the initial interview, but when it does, that's a red flag. Obviously, someone who's having to borrow money to hire a lawyer is a red flag, because we're like an automobile. You got to pump us up with gas to keep us going. And the danger there is if a client gets to where they can't pay our bill, and then we lose interest in their case. And then the next thing you know, we're getting a letter from the state bar because something didn't happen the way the client thought it should have happened, or we're not getting paid. It's always a conflict. There's always a rub. Client, and then on the other hand, you get the client who's got more than enough money, and they want to throw more money at you because they want you to do things their way. And the money is tempting, but again, that's back to, why would I want to subject myself to, even if I'm going to make some money on the deal, to doing something that I don't feel confident in doing or comfortable doing, just because the client's saying it and they're throwing money at me to do it. There are a lot of lawyers out there who will, let me rephrase that. I won't say there's a lot of lawyers. There are some lawyers out there who don't care, and they will take the money and they'll do whatever the client asks them to do. They're an impediment to the process, in my opinion. They ought to be ashamed of themselves, but it's a business. And when you're running your law practice as a business as opposed to a profession, then it doesn't matter. You just take the money and you run. And I think that's a problem.
When you meet with clients and there are small children involved, do you ever meet the children? Or do you not meet the children?
Small children, a lot of times, will come in tow because mom doesn't have anybody to do daycare. And so I've had 2- and 3-year-olds climbing around the floor in my office while I'm trying to have a conference with mom. And I have a 5-year-old at home myself, and so I've got plenty of toys here for the kids to play with. And but I don't meet with kids on purpose to talk to them about the case. I'm real hinky about doing anything like that. But occasionally I'll get a 10-year-old who just insists on telling the lawyer something. And so I will allow a child to come in and tell me what they want to tell me without engaging very much with them on that. Mostly because the child just needs to vent. And children do. Children will ask parents questions, and then when parents try to answer those questions, they don't always get it right. The kid gets the wrong idea. The other side, the kid then says something to the other parent then says something to the lawyer. The next thing you know, we're in the courtroom and they're accusing the client of talking to the children, trying to persuade them, and all they were trying to do was answer a legitimate question. And so I have to tell parents all the time, if your child is asking you a question, find out from me what the answer is before you say anything to them, unless you already truly know the answer. And secondly, be very judicious in how you tell them, because involving children in their custody case is probably one of the biggest mistakes a parent can make. The child, and it's also an equal mistake to keep children completely in the dark, okay? Because children do have questions. They are smart. They know what's going on. They have an idea of what needs to happen. And so, for them at least, and they see both sides because they're the ones that are in the middle. Parents will play kids against the other. Kids will play parents against each other. The dynamic really is a opportunity for a bomb to go off. But if a parent will be very patient in talking with a child, or I've done this, I've advised both parents, even though they're at odds with one another, to meet with the child and talk to the child together as parents. I think that's the healthiest thing they can do, as long as they don't end up having a fight in front of the child. But talking to kids is hard to do right.
Let me ask you this. What are the reasons under North Carolina law that one party or another gets sole custody of a child? And what are the circumstances under North Carolina law that a party has to pay alimony?
Well, so those are two different categories. Let me deal with the first one, and that is sole custody is reserved for cases in which there's some egregious circumstances. So if one parent has an alcohol or drug problem and it has spilled over into abuse or neglect of a child, or the child's been subjected to some injurious situations or dangerous environments. I like to tell people that everybody has joint custody until a judge takes that away. And the judge takes it away for those very reasons: abuse, neglect, or injurious environment. It's the same thing with the Department of Social Services, same standard for juvenile. And when a parent has abdicated their proper role as a parent, then the judge has to step in and limit what that parent's involvement is. I've had some cases where the religious faith is the issue, and judges have the authority to authorize one parent or the other to be in charge of the child's religious upbringing, or their medical attention, or their educational background. So because one parent is handling it properly and the other one's not. The most recent one I had was a dad who refused to acknowledge that his child had a particular mental health problem and needed medication and needed therapy, and was not going to participate in that process at all. And the judge granted my client sole custody because dad was very clear he was never going to go along with what was in the child's best interest. When it comes to alimony, I mean, clearly this is a no-fault state. So the party who earns the greater income pays the party who earns less, and they have to have been married for a significant enough period of time so that the marriage doesn't qualify as a marriage of short duration. But assuming that you've been married 4, 5, 6, 7+ years, then the supporting party is going to pay the dependent party an amount. We don't have a formula in North Carolina like they actually have in some other states. But essentially, we look at your income and your expenses and the other party's income and expenses, and the judge figures out some way to throw some money to the dependent spouse from the supporting spouse, hopefully so that they both don't become destitute in the process. It feels like it, but most people can get by if they will be frugal with their funds.
When you say a no-fault state, what does that mean?
Well, you can engage in adultery and alcoholism and frivolously spending money and all kinds of things, and those are matters of fault. But if you have a clearly supporting and a clearly dependent spouse, then those issues kind of aren't as important. You imagine a fellow who's earning $60,000 a year and his wife is earning $20,000 a year. She's going to be entitled to some alimony just because of the difference in their incomes. What happens if the husband also has been unfaithful? Then the court says he shall pay alimony. And if there's any belt tightening that has to be done, judges usually tend to let the offending party tighten their belt more. If the dependent spouse has engaged in marital misconduct, for example, infidelity, then they're barred from any kind of alimony at all. So infidelity being the only one that will bar that, everything else really is those scales of justice balancing back and forth. So you get these cases all the time where the wife says, well, he was mean to me and he cussed me out. And of course, he's got audio tapes where she's just letting him have it on the phone or letting him have it in person. And or she's spending a bunch of money or he's spending a bunch of money on his motorcycle. I mean, those things are all matters of degree, and we're all guilty of something. But the infidelity issue is the clincher. So that one seems to be still very popular.
Finally, as you look back on a career in family law, 39 years is certainly a career in family law. How would you assess your career? Would you, I mean, I know you're proud of it, but what makes you proud of it? What makes you feel good at night about what you've done?
So I think maybe one of the greatest compliments I ever got was from my youngest daughter. I had represented, well, let me back up. When my kids were in high school, at that point, they thought I had represented everybody in town because it just seemed like wherever they went, I had represented somebody's mom or dad. And I had to remind them that I could only have represented half of everybody, not quite everybody.
Right.
But the greatest compliment came a few years ago when my daughter came to me and was talking to me about a case I had handled 20 years ago. And this friend of hers was one of the children in the custody case, and how that child had talked about how much she appreciated what I had done in the case. And I've heard from kids. I've seen them after they've become adults, and they've talked to me and told me, how much they appreciated what I had done for that parent, or for both parents, quite frankly, in some cases. That's, I think, probably the greatest joy. And seeing people today, even today, seeing them going from when they come in the door and they're a basket case walking in, and then 6 months later or a year later, however long it takes, they're on their way, they're happy, they're adjusted, they're stable. And some of them, I've had plenty of clients who were alcoholics walking in the door and they were no longer addicted to alcohol. No, I won't say that. Alcohol was no longer a problem by the time we got done with the case, or drugs was no longer a problem. They'd overcome that. And that's always very, very satisfying to see people improve their lives one way or the other.
My last question I want to ask you is my favorite question of all. There may not be an answer to it, but let me ask it anyway. Is there anything that you think is important to say to listeners about what you do in the practice of family law that I have not asked you about or we have not discussed? Is there something we have left out that you know about?
Yes. And I think that is, there's no way to determine what your outcome is going to be. We have ideas of what it should be. But I tell clients frequently, when you're making decisions for your life, particularly for you and your children, you make the best decisions that you can, forgetting court, forgetting the legal process. You make the best good faith decisions that you can for yourself and your children, regardless of what the outcome is going to be at trial. Because in the end, we're just a Band-Aid. We're just there to fix whatever's going on at that moment. But your life goes on long afterwards. And focusing on that is making the best decision for yourself, will serve you better for years to come, regardless of what's happening in court. Jay Corponon, who's still our chief district judge, I was trying a case with one day with another lawyer where the parties had gone at it. It was really ugly. Both of us had 3-ring binders, these 5-inch 3-ring binders with emails and text messages back and forth, and it was as ugly as it gets. He was unable to have children. She conceived through the sperm bank. She had told him she was going to tell the kids he was not their natural father. He was going to tell the kids that she had formerly been a pole dancer, which was true. It was just that kind of stuff. And Jay had heard 2 days of that. And then his dad was down and they had gone to lunch, and he came back and his dad was sitting in the courtroom, and he started talking to us about how his time with his dad was more valuable after he turned 18 than before. He had good memories when he was a kid, but the relationship with his dad meant more to him now than it ever did before. And I think what happens is, if you walk into this process that you're going to get the other side, you're going to get them to pay, you're going to get them to do this or that, I'm going to win these kids, you have to live with those consequences. And Jay was absolutely correct. The time we have with our children after they've turned 18 is far more valuable, far more satisfying, far more productive for them and us than it ever was when they were 5 or 9 or 14 or 15. I mean, quite frankly, when my girls were 13 and 15, I was looking for a way to trade them for a good set of tires. I was a single dad trying to raise 2 girls. I didn't know what girls were. I couldn't understand them. And I was looking for the loophole in the murder statute for parents, which is not there. And it was just one of those times where I was just frustrated. And that's the way parents get. But both of my kids have turned out to be great parents. And the time I spend with them now is so much better than it was when they were little. So the advice would be, and the thing that we haven't talked about is, where do you go from here? What are you going to do next? And how is that going to impact the relationship with your children, or even the relationship with your ex? You know, one of these days, the 2 of you are going to be standing there at the church when your little darling's walking down the aisle to get married. How are you going to interact with each other at that point? And you're going to do damage to her most perfect day, her most valuable day. That's what we forget. We lose sight of the fact that there is life outside of family law. And if we don't plan for that, we don't make decisions based on that, then, well, not only are we short-sighted, but we're trading, in my opinion, a positive future with our children for a moment of retribution and retaliation and whatever else you want to call it.
I'm so glad I asked that last question. That's just all that you said. I hope that people will hear and listen to. That's so important. I would just want to thank you again for doing this. It's just, I think it's going to be so helpful to so many people. Thanks.
Well, I appreciate you having me. Thank you, Jim.